Okay, standard contract process for buying a franchise does vary a little bit from state to state, but not that much. Essentially, if you're buying an existing franchise, you will sign a contract to purchase that business, because it is a business, from the outgoing franchisee. At the same time, you will be asked to sign a fresh franchise agreement. Very rarely will franchisors assign the existing documentation. You'll be asked to sign fresh documentation, and it may in fact be different from the obligations that the outgoing franchisee has, and this is sometimes a trap. The outgoing franchisee might have been in that business for 5, 10, 12, 15 years, and these documents evolve and they change, and generally they swing in favour of the franchisor. So the obligations under which the outgoing guy ran his business might be different to what you're being asked to do, and that could be really pivotal. Things like additional fees, additional costs, new requirements, new product lines, all of those things may affect you when you come into the business under your new documentation that weren't obligations for the old franchisee, and that might affect your bottom line, and it might in fact affect the viability. But you'll be asked to sign those two sets of documents. Your contract will have a number of clauses in it which allow you out. Firstly, it will usually have a cooling off period, and it's a short period, usually about 5 days, during which you can walk away from the entire thing. Then you'll have a finance clause and a due diligence clause. Those two clauses allow you to walk away in the event that you're not satisfied with your due diligence, or that you can't, after reasonable effort, get sufficient finance to complete the purchase. And they will both have deadlines on them. Usually they're synchronized to be the same day, but not always. Once you've gotten through that process, if you've got your finance and you're satisfied, you will then proceed from that point to completion of the contract, parting with your money, getting possession, and going through into possession. One other thing that you might need to look at that is a showstopper is licensing. If you're a food outlet, if you're a manufacturing outlet, if you're a financial services responsibility act entity, if you're selling things like financial products, if you're a finance broker, if you're a financial advisor, there might be a licensing requirement, and your obligation to complete the contract should be subject to you being able to get those licenses or have them assigned to you. Once you get through all of that, your contract becomes what lawyers call unconditional, so there's no longer a way out. The following things happen. You get finance documents from your bank, you sign those, and your bank starts to get ready for settlement. Your lawyer will draft a whole range of assignment documents, things like transfers of licenses if they are able to be transferred, or new applications for licenses, transfers of business names, transfers of domain names. You will need to organise electricity and telephone transfers to keep telephone and fax numbers. You will need to set up things like electronic ordering systems if they're not already in place, PayPal and this sort of thing. The next thing that has to happen is that your lease, if you're running from some kind of outlet, some kind of business, whether it's a factory or a business, that needs to be assigned, and your landlord, or sorry, the outgoing franchisee's landlord, will need to consent to you coming in. Now, if that landlord is a large shopping centre, for example, they might have a lot of hoops and hurdles for you to go through, so you've got to get that done. Usually your contract will be subject to and conditional upon you getting approval from your landlord. If your landlord says, no, we don't want this person, they're not sufficiently experienced, or we just don't like them, then you can walk away. In the recent downturn in GFC, some landlords have actually seen this as an opportunity to stick a few extra obligations on tenants. Things like additional security, things like rental bonds, things like personal guarantees from shareholders, where previously there might have been personal guarantee only from the directors. So that is becoming a bit of a battleground now with business purchases, with the larger landlords trying to chisel more security out of incoming tenants. Once you get through all of that process, there'll be a formal settlement, usually with a stock take. If you have stock on site, there'll be a stock take, and there will be, if you're buying work in progress, that is uncompleted jobs. Let's say it's a steel manufacturing business. There will be jobs where there have been orders and haven't been delivery. There'll be a formula for working out how much you actually pay for that job that's partly completed. So the stock take and the work in progress process will be done very close to settlement, usually the day before or the day of. So on the day of settlement, you're in there, you proceed on the basis that your settlement is going to take place, so you're there and you're trading. Settlement days takings usually belong to you as the incoming buyer, but you need to check that in your contract and make sure that it hasn't been reversed. And your lawyer will generally ring you and say the settlement is completed, congratulations, you're now the owner of this business, and from that day on it's yours to have and to hold.